group all the exhibits that were recovered on your second visit. You remember, at the crime scene?
Re feletse mane he maobane mo ne re bua ka bopaki hore re tle re bo kopanye kaofela bopaki bo le hore o ile wa bo bukella kgetlo sa pele le kgetlo sa bobedi wa hopola. I recall.
Okay. When were they booked out from the safe?
Ore buile ba bukiwa out nini ho tswa safe.
30th of November.
They were
in the
booked.
morning.
They were booked out of the safe on the 30th of November in the morning.
And where is that proof? Where is that proof showing that these exhibits were booked out on this particular day?
Ke ho kae mo ho hlahisang teng kapa mo ho ngotsweng teng hore bopaki bona bo ile ba bukiwa out ka date e we buletse,
Including the name of the person who booked out the exhibits.
ho kenyeletsa le lebitso la motho o bukileng bopaki bo out.
Ke ne se ke fane ka SAP 459 ene se fumane le ka pla lekgotla. SAP 459 ene se ke fane ka yona ka pla lekgotla.
I had already handed over SAP 459.
But we don't have it here in court.
Ara habana arna yona pela lekgotla.
Did you hand it when you were testifying, Mr. Mosia?
O ile wa fana ka yona SAP 459 kana kwe o no be fana ka bopaki ba hao bo ka sehlolo.
Chair, the SAP 459 di fitisitswe ke Mchuchis.
No, the SAP 459 were handed over by the state prosecution.
Lobufakazi ke ekhulunywa ngabo lana ke ngakhipha noma ke bakhipha resafe nge-30 October 2014.
When?
Futhi ke i-SAP 459 ilena ke edluliswe umshushisi edlulisela enkantolo.
When was it handed over to the court by the prosecutor?
Ke neneng hane bopaki bo ba SAP 459 bo neelwa lekgotla jwalo ka bopaki.
Seo se ka arabelwa ke yena Mchuchis.
Only the state council will be in a position to explain that.
Umshushisi ke ongakwazi ukusho ukuthi bekuninike kati edlulisela le SAP 459 enkantolo.
Don't refer this court to something that you do not know. I ask you if that exhibit was submitted to this court. The answer is no, you don't know. Do you?
Yes, I do know.
You don't know or you do know?
Ke a tseba bana di tlisitswe ke colonel from Springs LCRC, the certified work commander from Springs LCRC at the end of Mchuchis.
Colonel Ma?
It's Colonel Ngomani from Springs LCRC.
Okay, I know because those evidence or SAP 459 were brought by a Colonel Ngomani, and they were certified by
my commander.
They were certified by my commander before they were handed over to the state.
Mr. Mosia,
ukuthi lama exhibits noma lobufakazi engikhuluma ngabo balethwa uyena uKenneth Ngomane wase Springs base ke bufakwa kwistab noma certified i-commander yami nayo yase Springs.
Mr. Mosia, I'm telling you that you are lying. That document has never been submitted before this court, and you were here.
Arase nnete ntho e buang hobane bopaki bo ha ba ka banelwa lekgotla ibile le wena o nontso le teng ka dinako tsohle.
It's about ke nnete ke buang.
Okay, let's proceed.
I believe that is the truth.
Lokho ngikushoyo ke ngikhuluma ukuthi noma ngithemba ukuthi kuyiqiniso.
I wonder what type of a witness you are, lying under oath on something that did not happen in front of us here in court.
Are we ipotsa hore mofuta o feng wa paki o kgonang hore o bue leshano o le ka tlase ho kana pela batho ba neng ba le teng kaofela?
Okay, let's move on. How were they delivered? Oh, sorry.
I really don't want to interfere with my cross-examination, but yesterday we went through this process. Today we're going through the same process again, and even the day before. And I think it's unfair to insinuate to a witness that is lying. A process that was already explained yesterday, another explanation is sought today. We submit my lord that it's very unfair to impute that to people.
Advocate Mchelolo?
Thank you, my lord. My lord, I am repeating this question because I had asked the witness, my lord, to show us proof that the exhibits, now I'm no longer referring to the bullets, my lord. I'm now referring to the exhibits that were recovered on the second visit.
But this witness said those were brought by Colonel Ngomane after they were certified. And they were brought. I don't know where he's saying they were brought. And your response is that he is lying. Is he lying when he says they were certified? Is he lying when he says they were brought?
No.
In what sense is he lying?
No, my lord, I'm not saying he's lying when he says they were certified by Colonel. But I'm saying he is lying when he says that proof was submitted before this court when he was testifying. Because that proof has never been submitted, my lord, before this court.
Mr. Musia, did you say the proof was submitted?
Tate Musia, now we say what about Pakibo, we live at least while the
Ke ne ke hlalositse mokgwa o bopaki bo bo fihlileng ka ona kwano ke sa hatelle hore bo hlaile ka pora lekgotla.
I was only explaining the channels on which that proof or evidence went through to be brought to court, not that it was handed over.
Maybe-
Kuchaza-ke ukuthi ubufakazi lobu bulethiwe noma buzisiwe kwaye futhi-ke indlela ekuhanjiswe ngayo kungasi ukuthi ubufakazi obudlulisiwe enkantolo.
Maybe you should be more specific what you mean by kwano. My understanding, my loose understanding is that kwano means here. So if it doesn't mean here where we are now, maybe you should qualify it.
Ekare o ka re hlalosetsa ha o re kwano o bolela kwano ho kae le kgohleng kapa kwano kae?
Ke tjho ho tloha Springs ho tla mo Pretoria.
I'm referring to from Springs, my lord, to here in Pretoria.
Engikushoyo-ke ukuthi ubufakazi bulethiwe bususwa khona-ke eSprings bulethwa la ePitori.
There you are.
Thank you, my lord. So, my lord, I was going to say, I said to the witness, that document was not submitted to this court. I don't know whether I should rephrase it or repeat it, my lord, because that is when I said, you are not telling the truth.
Yeah,
Because
but then we should establish first,
Yes, my lord.
or I should ask you first whether you heard him to say it has been brought here.
In this
to
court.
court. Yeah.
Yes, my lord, I did, my lord.
And did he say it was brought here to court?
Yes, my lord.
But he's saying he didn't say that.
There's
He's saying when he said it was brought kwano here, he means in Pretoria.
Okay, my lord, can I then just repeat the same question so that
Okay.
he can respond?
All right.
Thank you, my lord. Was that document submitted in this court when you testified in your examination in chief?
Na bopaki bo wile ba nehelwa le khotla ka nako eo o ne o fana ka bopaki ba hao bo ka sehlohlolong?
Tjhe, ka ba ka ba nehelwa morena.
No, it was not handed over.
Ubufakazi-ke abuzange budluliswe enkantolo.
That's the only answer I've been trying to get from you. I don't want to know whether they were moved from kennel to kennel, whether they were certified or not certified. The point is that proof was never submitted before this.
Re sa se tlhokang fela ke hore o arabele seo a se botsang. Ha botsa hore bopaki bo nehetswe lekgotla, karabelo ke eo o nang le yona e leng nnete, e seng hore o hlalose ditsela le ditsamaiso tsa hore e tsamaile jwang ya fihla kae ya tliswa ke bomang le dikolonele le di-commander.
Ho tlo
Thank you,
ha
my lord. Can
I understand, my lord.
We've already put in record yesterday that as soon as a copy of the SAP 459 was received, we gave it to Madeleine Friend. They are also copies available.
459.
Yes.
So we are talking about something she had.
Yes. We will give it to her.
My lord, I think the state is missing the point. The point is not that the document should have been given to me. I am saying, my lord, that proof has never been submitted before this court when you were testifying in your examination in chief, my lord.
There you are.
Yes.
Advocate Baloy.
So the giving of documents to me, I'm not the court, my lord. The document was never submitted before this court by this witness. That's the point I'm making, my lord. To prove that these exhibits were handled, kept like this, my lord. I'm not the one who's proving the case. It's the witness, my lord, who's supposed to prove his case, not via me, my lord.
Somebody is taking photos with a flash.
Yes.
Why? Advocate Baloy.
My lord, my learned friends demanded a copy of the SAP 459. Copies were then brought to court. We gave you a copy, and I indicated yesterday that we do have copies. A trial is not, it's not some sort of a game. I indicated yesterday that the document is available to my learned friends to cross-examine the witness. I think it's unfair to sit with the document and cross-examine the witness on the document that we're sitting on.
No, the point she is on is that as this witness testified, that document was not presented to court through this witness.
Indeed, it was not available at that stage.
Okay.
Thank you, my lord. That's all.
Let's proceed.
Thank you, my lord. Thank you, Mr. Sofu. Let's continue then. When were those exhibits delivered to the forensic?
There's a point I missed, Mr. Musia. You said they were booked out of the safe on the 30th of what month?
Already let's answer ka da bukiwa auto ka di 30 tsa kgwedi e feng.
Tsa ka di 30 tsa October mrenaka.
On the 30th of October.
What year?
Lemo se feng.
2014 mrenaka.
The year 2014.
Okay, thank you.
October 2014.
Thank you, madam. When were they delivered to
Sorry,
the
I can
forensic?
just put in record that it was incorrectly put in record previously that it was the 30th of November. It was in fact 30th of October.
Yeah, that's what's bringing me to ask a specific question, because I had 2 months mentioned.
And then also, my lord, it is wrong for the counsel for the state to rectify what has been said by this witness. If it has been incorrectly said by this witness, it's only this witness who is going to testify on that in that regard.
Did he rectify?
No, if he's rectifying it, my learned friend, my lord, is rectifying it.
What did he
The
what did
date.
he-
The date, my lord.
Which date? Because I asked the witness a specific question. Actually,
As to when
yes,
were the exhibits
Yes.
booked out.
and he said it's the 30th of October
October.
2014.
Yes, and then the defense, the state counsel is rising up now to say the date has been incorrectly set by the witness and referred to as 30 November, if I got that correct.
I didn't say it was incorrectly said by me. I said it was incorrectly conveyed on record during the interpretation.
Thank you, my lord. I understand it. The problem is that the state counsel is distracting me, my lord.
There you are. You have been very apologetic, saying you don't want to distract. You are accused of distracting it.
But the fact of the matter is the record has got to reflect what has been said in court. And if it distracts my learned friend, that's unfortunate. But we just have to make sure that the record reflects what has been said. That is a point.
Sorry, madam. It was not the interpretation. It came straight from the witness, 30 November. So I just want to rectify that. It was not interpretation.
Thank you.
It came straight from the witness.
Thank you, my lord.
Then let's stretch it out. There are 2 dates you mentioned, 30th November and 30th October. Can you clarify us once and for all?
O buile ka date tse pedi 30 November le 30 October. Re kopa he o re hlakisetse e leng yona ke efeng.
E leng yona ke 30 October morena ka ke bile phoso nyana.
The correct date is the 30th of October. It was just a slip of a tongue, my lord.
I-date ke bekuyiyona noma kwakuyiyona i-30 October ngasiyona ke i-30 November ngendlela iphutha.
If it was a slip of a tongue, my lord, it is not supposed to be rectified by the State Council.
No, the record is there, we can play it back if it turns out to be, such a crucial aspect. But I think the record is there, it speaks for itself.
Did Mr. Baloyi rectify?
Yes, my lord.
What did he rectify?
He said it has been incorrectly said, it has been incorrectly referred to November instead of October.
There you are, Mr. Baloyi.
No, that's the record is there, it speaks for itself. I think the witnesses, since it's water under the bridge, the witnesses since repeated what.
Okay, let's proceed then.
Thank you, my lord. When were those documents then submitted to the forensic?
The same date, ka lona letsatsi leo la di-30 it's October 2014.
They were submitted on the very same date, which is the 30th of October 2014 in the morning.
Labo bufakazi ke bayadluliselwa ke kuma-office ama-forensic ngalelo langa lelo akhishwa ngalo 30 October 2014.
By who?
Di fetisitswe ke mang kapa di isitswe ke mang ho ba forensic?
Di isitswe ke nna ka letsoho.
They were personally hand delivered by myself.
Ufakazi lobo basiwa yimina ke ngesandla.
Yes.
Were you given a proof of receipt of those documents at the forensic?
Wile wa fiwa bopaki bo bontshang hore di amohetswe ho ke ba forensic.
Ho jwalo morena.
That's correct.
Nganikezwa ke ubufakazi ke noma ke i-receipt eshoyo ukuthi ngakudlulisa ubufakazi.
Where is that proof
Bopaki bopaki bo
that you were given?
bo o bofueng ka nako e o nehelanang ka bona bopaki bo.
Se kile ka tlhalosa ka mokgetlo ka pela lekgotla lena hore bona le dintho tse ke itleng ka sitise hore ke di bokeletse ka lebaka la seemo sa ka sa bophelo ke kgone hore nka ya hodimo le tlase ka ipatlela le se ke tlhalositse.
I have already testified before this court that because of my ill health, I could not be in a position to move around and gather all the evidence that is required to bring it.
Bese ngishilo noma ngichazileke ukuthi ngenxa yesimo sempilo yami ke angikwazi ukuthi nje kubeke indawo zonke ngisukela ngiyela ngiyohlanganisa ngithole bonke ubufakazi obudingekayo enkantolo.
So we don't have it.
Ka mantswe a jwalo o re ha boyo pela lekgotla bopaki bo jwalo.
Ile ka etsa ka latellisisa tokete ka ya photo album ene kile ka re ila ya Buka Springs e ka re ithola hetse ku Johannesburg la isoka e fitla hone
In docket.
tokete ya photo album.
Okay. I followed up on the docket that contains photo album on which I compiled, which was at Springs. I heard that it was now in Johannesburg, and I made request that it should be brought to me.
Okwenzekileke ngiye ngazama ukuthi ngihlanganise noma ngitholeke idokodo engangizwileke ukuthi la noma ilalise Springs la mangabe ngilifuna noma ngilicela elinezithombe bathi ke lise Johannesburg ngisenzileke isicelo sokuthi bangilethele lona noma benze isiqinisekiso sokuthi ngiyalithola.
Okay. Let us not make things worse, Mr. Mosia. Just confirm for me that when you were testifying, you never produced that document that you received from the forensic when you delivered the exhibits.
Ha re etse dintho di be bobebe.
Forget about reasons.
re tlohele ho fana ka ditlhaloso tse ngata. Ka nako eo o ne o fana ka bopaki ba hao bo sehlohlolong. Ha wa ka wa hlahisa bopaki boo.
Well, I think to that he has already conceded that it was not.
My Lord, at the risk of incurring the wrath of my learned friend, the witness in his evidence in chief did refer to the acknowledgement of receipt that he received. My Lord. It's there on record, and it also forms part of the exhibit as A3 in brackets 2. He referred to that in his evidence in chief.
But is he not saying we don't have it? Because it was not handed in at the time this witness.
But the question is that he never referred to that to that in his evidence in chief. I'm saying it was referred it was referred to in his evidence in chief. So I'm saying that statement is incorrect, my Lord.
There you are.
No, my lord, that is also not correct. The witness is correct. The document or the receipt, acknowledgement of receipt that he received from the forensic on that day, it's not before this court. And the document as per Exhibit B5, I'm not sure if my learned friend is referring to that. It's not the document that was given to this witness, my lord.
My Lord, we've been through this on Friday. The witness, and I'm referring to as recent as Friday, and I'm not even referring to his evidence in chief, to his cross-examination. He referred to Exhibit A3 in brackets 2. It's on page 12 of Exhibit A, and he said, even if it's not the original, but it's a copy thereof that he received. So he mentioned that in his evidence in chief, he mentioned that in cross-examination as recent as this past Friday, my lord.
Yes.
My lord, I'm no longer referring to the proof of delivery in respect of exhibits contained in Exhibit A, my lord. I am now, yes, I did ask that question when I was referring to Exhibit A, but now, my lord, I've moved on. I'm now on the exhibits in respect of Exhibit B.
Mr. Musia, those acknowledgement of receipt by the forensic lab regarding Exhibit B.
My lord?
Yeah.
The question is?
Regarding the acknowledgement of receipt by the forensic lab where it regards Exhibit B.
Boteng bopaki bo bontshang hore ba forensic ba ile ba amohela bopaki bo ho ya ka Exhibit B.
Ke tshepa jwalo mronaka ke ne se ke entse matsapa a hore ba ntlisitse docket ho tloha Johannesburg ke sa tsebeng hore na ba tla phomella ka nako na.
I believe so, my lord. I had already made a request that they should bring that docket from Johannesburg. I just hope that they will arrive on time.
Isicelo ke ngisenzile ukuthi idokotela lelo ke bangiphathele ukusuka ke eJohannesburg. Ngiyathemba ukuthi bazofika ngesikhathi.
Yes.
So my lord, that is the reason I was saying to the witness, right now as we stand, that acknowledgement of receipt has not been submitted before this court. Yet, let me say yet, because we have requested it.
Ho tla bolela hore bona bopaki bo ha bo soka bo fetisetswa pela lekgotla ka semolao hobane o santsane o boemetse hore bo fihle na ho jwalo.
Ho jwalo mronaka.
Okay.
That's correct.
Thank you. And then let's go back, Mr. Musia, to the scene just on 2 issues. Can the indictment be shown on the screen? Count number 3 now. Maybe what's their, okay. Let's count 1. Count number 3. Can you just scroll up? No. Wherein it says in that upon about the date, but in respect of count number 3, that's where I want. Yes. Count number 3. Yes. Mr. Musia, do you see that count? It says in that upon or about, count number 3, 26 October 2014 and Etonia Fosloras in the district of Boyersburg, the accused did unlawfully and intentionally assault Miss Kelly Kumalo, stroke Gladness Kumalo, and did with force and violence take a Samsung S4 cellular phone, the property or in the lawful possession of Miss Kelly Kumalo or Gladness Kumalo, and did rob her of the same, aggravating circumstances being present in that the accused made use of a firearm. Do you see that count?
O a bona qoso eo ya boraro hore e bolela hore monghadi Musia.
Okay, bona morena.
I can see that count.
And
ngiyabona ke lesimanga lesiqeda ufunwa manje sokuthi ke kwabanjwe inkunzi ke uKhweli Khumalo uGladness Khumalo kwase kusetshenziswa isibhamu futhi bathathelwa ke ne-cellphone eSamsung.
And there is also, my lord, statements. 2 statements. The first one is A12 statement that was made by Gladness Khumalo. In paragraph 6, my lord, I would like to apologize that I did not inform the state timely in order to make an extra copy for the court, but I'll just make sure I will refer to the paragraph as is.
You have since made copies.
Oh, thank you.
The quality of the copies, they are not legible, my lord. They are for poor quality. I'll just hand up the original documents from which copies were made.
Thank you, my lord. I'm starting with the A12, my lord, for Gladness Khumalo. A12, my lord.
Yes.
In paragraph 6, my lord, wherein it says the other one took Samsung S4 cell phone from my hands.
E mong wa bona ya ba o nka Samsung S4 letsohong la ka.
Yes.
And also from the statement of Zandile Lorraine Khumalo, my lord, SPA 13, paragraph 17, my lord. Wherein she says in that paragraph, my lord, I also saw first suspect fighting with my mother and took Samsung S4 cell phone with cell phone number 0729382498. Close court, my lord.
Ya ba ke bona e mong wa ba bilaelwa ang lwantshana le mme wa ka mo a ileng a nka ho yena phone ya Samsung.
Esinye ke noma ngomuntu ofundwayo ke westatement sakhe uZandile Lorraine Khumalo la asho khona ke ukuthi wabona omunye kwabasola elisana noma wakhe.
And that is paragraph.
Sorry, my lord.
Paragraph.
Paragraph 17 of 813, my lord. And then paragraph 6 of 812.
Yes.
Thank you, my lord. Mr. Musia, are we on the same page? Did you get the reference I've just made from two statements and from the indictment?
I'm watching.
Okay. Now, as the first, I'm not sure whether should I refer to as an expert at the crime scene, as the first person who arrived at the crime scene. Okay? And you have, I assume that you have received information that there was a robbery also that took place at the crime scene. I'm not sure, you'll correct me if I'm wrong.
Jwalo ka ha o fihlile pele sebakeng sa ketsahalo ya ba wa o no sontso o na le tsebo ya hore ho ile ho ba le ho tshwaruwa poho sebakeng
I
seo.
just want to object to this question based on the fact that this witness was not the first witness to arrive at the scene with regard to facts of the matter. He was not the first witness. He said he was the first witness, he was the first expert to arrive. He was not the first witness.
There you are.
My lord, I can put it either way. I am the one who is cross-examining the witness. I know the point where I'm going to.
Yeah, but you're not going alone.
Yes, my lord.
You're going with us.
I said, my lord, now I can no longer refer you to as an expert. I'm now saying as a person who was in the crime scene on official duties.
And
I still insist with
you
my
have dropped
objection.
you have dropped the word first.
Sorry, my lord.
Have you now dropped the word first? Because I think the objection was sparked by your use of the word first.
Oh, thank you, my lord. As the person who arrived at the crime scene as an expert.
Yeah?
Is that fair, my lord?
It's not me who wants fairness, it's your
No.
colleagues. I think ask your question. If they still have objections, they shall.
Okay. Mr. Musia, did you ask the witnesses? Did you verify from the witnesses if there was any cell phone that was robbed?
Ntate Musia, jwalo ka o ile wa fihla sebakeng seo sa ketsahalo jwalo ka setsebi. Na hona le batho ba ka hare ba ileng wa ba botsa hore ba ile ba nkelwa di cell phone tsa bona kapa tjhe kapa hona le seo ba se nketsweng?
Tjhe, nka ba ka botsa di-witness letho.
I did not ask anything from the witnesses.
Angizange ngibabuze lutho ke ofakazi noma labo engabafica ke belapho ngokuphathelene nokuthi babanjwe inkunzi yini base bephuthelwa ama cell phones.
Okay, but were you informed if there was any robbery that had taken place as well during the shooting incident or when the incident took place?
Na ba ile ba o jwetsa hore ho bilwe le ho tlatlapuwa kapa hore ba nkelwe dintho ka nako eo ho thungwa ba kapa motho?
Ha ke thola ketsalo mahaleng wa ka e hlalositswe e le house robbery and murder morenaka.
When I received the information from the call that I received, I was informed that it was a house robbery and murder.
Uma ngabe sengithola ke umbiko kucingo engalithola ngatshelwa ke noma umbiko wathi ke kubanjwe inkunzi emuzini noma kuyindlu kanye futhi ke nokubulala.
Okay. After receiving that information, did you inquire as to the items that were robbed? Which items were robbed during the incident?
Jwale he ha o so e etsa dikhuputso tsa hao na o ile wa botsa hore ke eng e ileng yang bua ka nako eo ho tshwaruwang po.
Ke tshepa jwalo le ha ke sena dintlha ho nna ka toketo e leng Johannesburg e ke reng ba tla tla le yona.
I believe so, even though I don't have full information. It's in the docket that will be brought from Johannesburg.
Ngicabanga ukuthi ngabuza ukuthi yini ke noma ikuphi ke okwathathwa noma ke nginayo ke imininingwane ephelele ngoba ngisalindele le dokotela kuya eJohannesburg.
So you can't recall at this stage?
Hana jwalo ha o hopole ka botlalo.
Ke kopa ho refera ho first reports first information of crime to analyze crime scene.
Can I refer to the first report of the person that I found at the
No, don't worry, Mr.
crime
Musia.
scene?
If you can't recall, there is no sin there. Just tell the court that I can't recall.
Are ha bene o ha o hopole ha se sebe e re fela ha ke hopole.
A ke hopole morena.
I don't recall.
Uthi ke ngakwenzeka ke impela angikhumbulile.
And as a result of that, there were no traces that were done by yourself regarding this cell phone in the crime scene when you arrived for the first time.
Ka ha ba le ho latellwa ho bona hore di cell phone tseo di ka tracewa jwang ka nako o no ile sebakeng sa ketsahalo kgetlo la pele.
Ka ha nna ke motho a shebana le crime scene ke tshepa hore re thusana le detective ka dintlha tse ding ha a bona di le bohlokwa ke ena a tla di latella.
As my duty was to secure the crime scene and I was working together with the detective, if the detective saw it fit that that should be done or the cell phone should be traced, he would have done so.
Okwami ke bekuwukuthi kwindawo yesehlakalo ke ngixoxe nje noma ngihlanganiseke la khona lapho ke futhi ngisebenzisana kanye naye ke umseshi wecala uma kuyena ke bekusemqoka ke ngicabanga ukuthi ke ibizolandelelwa ke leyo cell phone.
But according to your knowledge, I'm just asking your knowledge, there were no traces that were done by yourself.
Ho ya ka tsebo ya hao sebakeng sa ketsahalo ha ho ka ho latellwa ho kapa ho etswa di traces tsa ho bona hore di cell phone tse di ka fumaneha.
I
cannot answer that question.
Ukuthi ke yalandelelwa ke leyo cell phone ke ngokwazi kwami angeke ngikwazi ukuthi ngiphendule leyo mbuzo.
Did you do any traces of this cell phone at the crime scene when you arrived for the first time?
That has been answered to. You asked it and he said no.
He said he cannot comment, my lord, he cannot answer.
Yeah, you don't want that answer.
Sorry, my lord?
You don't want that one?
No, I don't
answer.
want that answer, my lord. I want the
Okay.
answer, the real answer.
Do you have another answer?
I don't have any other answer, my
Anginayo
lord.
ke impendulo enye impendulo ngaphandle kwale nginikeze yona.
Thank you, my lord. Then can we move on to the crashes, Mr. Musia? You can just open the exhibit B. If you'll be able to, if this exhibit is depicted there, I'm not sure. You know the exhibit, you have been testifying about it. I'm now referring to the crashes which were said to have been used during the commission of the offense. Do we have any pictures of the crashes? Mr. Musia?
Exhibit bundle A.
Exhibit bundle A. Mr. Musia, you can use the exhibit in front of you.
O ka sebedisa bopaki ba hao bo o nang le bona pela hao monghadi.
47 of Exhibit A.
I'm the one who is leading this witness, my lord.
I'm just assisting the.
No, I don't need assistance.
She was asking what the relevant exhibit is, and I'm just assisting that is exhibit bundle A.
My lord, I don't need that assistance. I'm the one who is leading at this point in time. Mr. Musia, open the exhibit piece in front of you.
It is photo 5 and photo 6 and photo 7. The place crusher air toilets in kitchen.
Photo 5
And open it on the screen as well.
Photo 6 and photo 7, they depict the crash, the crashes that was in the kitchen area.
Isithombe ke u5 u6 kanye no7 ke tshengisa noma bonisa yona ke le crash yatholakala ekitchen.
And also according to, or in reference, my lord, to A13 statement by Zandile Lorraine Kumalo, he says, I took one of Tumelo's crashes and hit the second suspect.
Andile Kumalo o hlahisitse statementeng sa hae hore kile ka nka engwe ya di crashes tse kapa di kroko tse ya ba ke otla e mong wa ba belaelwa ka yona.
Did you hear that?
Utlwe seo
Or should I repeat?
kapa o batla buseletse hape.
Ke utlwile morenaka.
I heard that.
Ngiyakuzwa ke lokufundwayo ukuthi istatement sakhe uZandile Lorraine Kumalo uthi ke wathatha ke enye kwamacrash akhe uTumelo waseshaya ke omunye wabasolo.
So it means this crash that is depicted in Exhibit A as per photo number 5, am I correct? 6 and 7
That's correct.
had been used during the commission of the offense.
Ho bolela hore kroko e hlahellang photo 5, 6 le 7 di e sebedisitswe ka nako ya ketsahalo e.
A se dintlha tse ke di thotseng ha ke ne ke le ketsahalong eo morenaka.
It was not the information that I got when I was at the scene of crime.
Angizange ke lo mbiko wako noma leyo mniningwane ke ngiyitholeke ukuthi le crash ke yasetshenziswa nkathi kwenzeka isehlakalo.
Okay.
By the
But
way, who is alleged to have used the crash?
the crash, my lord, it's Zandile Lorraine Kumalo who says, I took one of Tumelo's crash and hit the suspect with it, my lord.
Okay.
So the point I'm making, my lord, is that the crash had been used during the commission of the offense.
Yes.
Thank you.
Let's proceed.
Thank you, my lord. But you did find it inside the house when you arrived.
Empa o ile wa e fihlela kroko eo ka hare ho ntlo ka nako o fihlang.
Jwale morenaka.
Correctly so.
Kunjalo ukuthi mangifika endlini ke kodwa yona ke ngayithola ke noma ngayibona ke lapha.
Why did you not take it, or did you take any samples? Did you take any samples from the crash?
Na hona le di samples tse ileng wa di nka ho crashing eo, krokong eo.
Ke se ke araba kgetlo la bobedi. Ke tla e araba hape potso eo morenaka. Ke se ke tlhalositse hore dintlha tse ke di thotseng ha ke fihla. Crash e ine ile ya emong ya bane ba le ka tlung. Jwale ka bona ho sena bohlokwa ba hore nka e fuputsa.
I've already responded to this, but I will respond on it again, my lord. These crashes belongs to one of the people who were inside the house. Hence, I did not see it necessary for me to do any further investigations on it.
Bese ngikuphendule kabili ke lo mbuzo ngizophendula ke futhi ukuthi yona ke icrash lena ke kwathola noma ngathola ke mangifika khona lapha ukuthi yomunye walabo ababephakathi endlini angizange ngisiboneke isidingo sokuthi kube nophenyo engikwenzayo kuyona.
So in other words, you did not get this information that it had been used.
Hawaka wafumana information ya hore ile yasetshenziswa.
Ho jwalo morenaka.
That is correct.
Futhi ke angizange ngitshelwe ke ngathi ngifika ukuthi yasetshenziswa.
Yes.
Thank you, my lord. Those are my questions so far with this witness, my lord. I am now intending to cross-examine this witness in respect of exhibits C and D, which are before this court.
Yes.
Unfortunately, I cannot be able to proceed with my cross-examination at this stage, my lord, on the following reasons. Number one, my lord, the statement referred to as Exhibit D, which was made by the witness who is in the box, Mr. Mosia.
Yes.
Was never disclosed to me, my lord, before the trial started. I was only surprised when it was handed in when I was here in court.
Yes.
As a result of that, my lord, I have engaged the state requesting this docket. Because, my lord, you'll notice that it's the second docket because it's in reference of Force Laura's case number 375-01-2019, which is a second docket, in other words, my lord, in this case.
Three, 7, 5.
Force Laura's 375/01/2019.
Yes.
And this statement, my lord, that is before this court now, makes references of which I would like to cross-examine the witness regarding that. And my lord, I cannot be able to proceed with cross-examination on this document without reading the whole docket wherein this statement is contained. After engaging, my lord, with the state regarding this docket, I have been given this docket, my lord, this morning by the state. As a result of that, I have to or I need, my lord, with your respect, I need time to go and read this docket so that I can be able to cross-examine Mr. Mosia further. Further to that, my lord, in respect of Exhibit C, which is also before this court,
Yes.
I have requested, my lord, the State Council to confirm to me the content, my lord, of this exhibit before I can be able to cross-examine Mr. Mosia regarding the content of this document, and also in order to determine if there is any need to cross-examine Mr. Mosia regarding this document. I've also requested the state, my lord, because this exhibit is relevant in preparation of accused number 5 defense case. In that, my lord, Exhibit D refers to the facts, same facts of this case, my lord, that it is before this court. But it was opened later in 2019. And in Exhibit D, my lord, the Director of Public Prosecution, South Gauteng, had decided that the following people, my lord, be charged, which is number 1, Longwe Twala, number 2, Kelly Kumalo, number 3, Gladness Kumalo, number 4, Zandi Kumalo, number 5, Tumelo Madlala, number 6, Mtogozi Sitwala, number 7, accused 7, it's Maggie Peer, my lord. On 2 counts, my lord. Count number 1, the DPP has decided that they must be charged on the count of murder, in that upon or about the 26th day of October 2014 in Etonie, Boksburg, in the sub-district of Eburuleni, the accused, whose name I've just read into the record, my lord, who acted as perpetrators or accomplice or accessory after the fact, unlawfully and intentionally killed Senzo Meyiwa, an elderly person, by shooting him. And count number 2, my lord, is defeating the ends of justice. In that, on or about the date and at or near the place mentioned in count 1, the accused did unlawfully and with intent to defeat or obstruct the cause of justice, commit an act to wit, accused number 1 to 6, they hatched a plan and informed the police that they were robbed at gunpoint by unknown persons. Accused 7, she claimed the crime scene prior to the arrival of the police, which acts defeated or obstructed the administration of justice. My lord, as a result of the content contained in this document, It shows that there is a conflict of interest, but I cannot be able to make that submission before this court until I get a confirmation, my lord, from the author of this document before I continue with the cross-examination and any submissions further, my lord.
Can you repeat the names of the people who are supposed to have been charged?
Thank you, as the court pleases, my lord. The name of those people, my lord, as per the exhibit C, my lord, which was not brought by myself. The person who was supposed to be charged is accused number 1, Longwe Twala. Accused number 2, Kelly Kumalo. Accused number 3, Gladness Kumalo. Accused number 4, Zandi Kumalo. Accused number 5, Tumelo Madlala. Accused number 6, Mtogozi Sitwala. Accused number 7, Maggie Piri. They are on page 5 and 6, my lord, of exhibit C.
Mtokozisi who?
Sorry, my lord. Mtogozi Sitwala.
And 7?
7, Maggie Piri, my lord. My lord, as a result of that, my lord, if there are 2 decisions taken by, one taken by the Director of Public Prosecution South Gauteng, and the other one taken by the Director of Public Prosecution North Gauteng to charge the accused before this court, then I need clarity on that, my lord, from both or from the NPA before I can be able to proceed with cross-examination regarding this document that is before this court, my lord. My lord, in respect of the case docket as per Foslorus 375/01/2019, the non-disclosure of such document to accused number 5, my lord, violated his rights to be given further particulars, all information that is in possession of the state, my lord, in order to be able to prepare his defense, my lord. And this is the second violation, my lord, of accused number 5 constitutional right. My lord will recall that at the beginning, I also had to ask the postponement because of the late disclosure of the documents of certain witnesses 2 weeks before the trial started. And now the whole docket is only disclosed during the trial, or when the trial had already started, whichever way, my lord. The accused number 5 has been prejudiced by the behavior of the state in this matter. And as a result, or as such, my lord, I am not in a position to proceed with further cross-examination, and I need time, my lord, to go read the docket and consult with my client before I can be able to proceed. Those are my submissions, my lord, in respect of this application, as the court pleases me.
Mangalela wehlanu nanjengoba lokhu ke kuchaphazela wena ummeli wakho ke useqedile ukuthi abuze imibuzo ngayo ukuthi uqedile kodwa ke kulena ebenayo ke kodwa ke kunezitatimende ezimbili uexhibit C kanye no D afisa ukuthi aqhubeke ngazo ebuza lofakazi ngazo kodwa ke leso statement kakhulukazi ke uD siphathelene nale case number EU37501/2019. Kodwa ke ngeshwa idokotela khona ke ebengenalo isikhathi eside futhi ke uqeda ukuthola namuhla ekseni, usafisa ke noma kusafanele ke ukuthi ayohlala phansi alifunde abese khulumisana nawe ke ngenqubela phambili ngokubuza kwakhe imibuzo yena ke lofakazi lona. Futhi ke okunye lelo dokotela lo ke linabantu ke elibashoyo noma ke kuneyinqumo ezimbili ezithathiwe lana. Isinye isinqumo ilesi esithathwe khona la eNorth Gauteng ukuthi ke kube yinini abamangalelwa abasolwa kushushiswe nina. Esesibili ke isinqumo esithathiwe ilesi esimayelana no-case 37501/2019 lapho ke ubafundile noma ubashilo abantu ekuthiwa ke eSouth Gauteng kufanele ukuthi kube yibona abantu abavela phambi kwenkantolo. Labo bantu ke uLongwe Thwala, owesibili ke uKelly Khumalo, owesithathu uMegni Khumalo, owesine uZandile Khumalo, owesihlanu uTumelo Madlala, owesithupha uMthokozisi Thwala, owesikhombisa kube uyena uMeggy Phiri. Fanele ke ukuthi konke lokho ayokuhlalela phansi akakulungele bese emuva kwalokho ke ukhulumisana nawe nizwane ke ukuthi inqubekela phambili noma inqubekela phambili mayelana nemibuzo enizoyiphonsa kulofakazi izohamba kanjani. Yileso ke noma yileso isicelo esifakwa ummeli wakho enkantolo. Uzwakele baba.
Advocate, I don't know, I don't know whether you should respond now or whether we should allow Mr. The representative of accused number 124 to have his say around
Your
this.
Lordship, since it's tea time, we were suggesting that maybe we respond after tea time. But the bottom line is we don't object to the postponement. However, we'll state our reasons after tea. Madam.
that happened in this case, which in my humble view didn't have anything directly to do with this case. I'm saying this to say to you, finding time and ensuring that this case is speedily finalized has been my objective from the word go. And in due time, we had convinced your colleagues to be of that idea. And when we were just there, I mean, where you will remember that each time we postpone a matter, there are other matters that come into the fray. And we were fortunate in that the DJP was willing to deliberately make that happen, but we could not. But maybe this is awakening us to go back to the original plan, to see the DJP and agree on enrolling this matter en bloc. But I don't think I can be convinced to go along lines that will deny Advocate Mshololo reasonable time. I haven't heard her about the postponement.
I do agree with my lord. Yes, I submitted earlier before adjourned that we don't have a problem with adjournment, postponement, but we suggest a shorter period. We agreed. Then there was change of minds that no, it must be a lengthy one. Then I will also submit, I agree with the court that maybe we meet the DG and we discuss the end block. Because like on Friday, tomorrow and Friday we are all free. Unless something will come up, but we can arrange that even next week because we're supposed to come back again next week. Our submission was that we give our colleague 3 days, even if it's not enough.
No. You see, when you start to say 3 days, even if it was in my mind, you make it difficult for me to suggest to Advocate Mshololo 3 days, because then it seems
My
like
lord,
I'm
yeah,
taking...
Sorry to interrupt, Mama. It's what we were discussing. Then she said to us she will come back to us on Monday to find out whether she finalized it. However, with regard to the time frame of the postponement, I'll leave it in the hands of the court, but not the lengthy one.
Yes.
Then
I mean,
before...
to do justice to this case, we must just avoid it dragging. Remember,
Thank you.
there are people in custody.
Thank you, Mala.
And there's a family waiting to hear what happened.
Thank you.
So if we keep that in mind all the time, I think we'll be on the right track. But I've heard you. Maybe I should hear Advocate Baloyi. Advocate Baloyi, I interrupted you, but...
As a court, please, my lord, I've already indicated that we also just received the 2 copies this morning, and I made 1 copy available to Advocate Mshololo, and I also have a copy. And I've indicated to Advocate Mshololo that we will not oppose the request if she needs time to go through the docket in order to further cross-examine the witness. The only issue at this stage, my lord, is the length of time, and obviously we'll be guided by the length of time that Advocate Mshololo requires to go through the docket. She indicated that she might need to consult after going through the docket. And the other predicament that we're sitting with is the witness might not be available if there is a longer postponement, as he must go back for surgery, my lord. He indicated that he will get a date at the end of June regarding whether further surgery is needed, and if so, the date of the next surgery. So there is the other problem that we are seated with, my lord. I can only mention at this stage, my lord, that it's not due to any fault of the state that we received the docket regarding Phosphorus 3751/2019 only today. On the 23rd of March, and it's already on record, my lord, that there are 2 investigating teams in this matter. On the 23rd of March, I dispatched a letter to the other team, alerting them to the fact that this case docket is going to feature prominently during the current proceedings, and that we need a complete copy of the docket so that we can make a copy to both sides of the defense. And for reasons unknown to the state, it was only disclosed to Advocate Defo and not to the prosecution or accused number 5's legal representative. Yesterday, I then contacted. In fact, before the last adjournment, I requested the current team, the investigating team in this matter, to try and obtain a copy of the docket, and they were unsuccessful, my lord. But I don't want to go into that. Fact of the matter is, the docket was only received this morning, and we're not going to oppose the request of Advocate Mshololo to peruse, to get time to peruse the docket. As far as the second issue is concerned, my lord, regarding the status of Exhibit C, I've indicated to my learned friends that we'll be calling the status of Exhibit C is, as the court would have seen, is not even signed. We will call witnesses to testify about the circumstances under which, or the status of Exhibit C. That is far as I can take it, my lord. And that is an issue that has got nothing to do with this witness. It's an issue that will be resolved during the course of the trial, when those witnesses whose names are mentioned in Exhibit C come to testify. I think the only relevant issue at this stage, my lord, it's the fact that Advocate Mshololo, as well as the state, received the copies of Phosphorus 3751 of 2019 this morning, and as indicated, the state will not oppose the request of Advocate Mshololo to go through the docket. Initially, the idea was that perhaps we adjourn until Monday, and that we come back on Monday to get an indication of how far Advocate Mshololo is. But just before we resume, she indicated that she might need to consult further, and that will take us outside the time that has been set aside for the current sitting, which is until next week, Friday, my lord. And yeah, you know, we are now, if we have to postpone for a longer period, we are looking at the 5th of September. That is the next available date, from the 5th of September until the 16th of September.
Which if somebody spoke about witnesses, the witnesses that are likely to feature, or let me say the number of witnesses. I mean, that person was not a prosecutor in this case, but you are talking about the time period you are mooting. Will it be sufficient to bring the trial in this case to completion?
No, not at all, my lord. This will be just for the finalization of the cross-examination of Sergeant Musia and the rest of the witnesses, but and the leading of the other witnesses that will follow after Sergeant Musia. It's not intended to be a date for the hearing of this matter until it's finalized. Not at all, my lord. We need much more time.
Yeah. Yeah, which is why I am beginning to say, why don't we go back to the intention we once had, but for Advocate Tefo, to try and achieve an en bloc placing in the role, an en bloc enrollment of this matter, so that we can be able to dispense with a chunk instead of just a piece of what there is to be done. It's a pity Advocate Tefo is not here, but that's what I suggest we do, because this matter, from what we have already heard, took forever to land in court. It will be very unfair if it again takes forever to see finalization within a court. So I would suggest that we go back to the initial intention to come together and explore an en bloc enrollment that is subject to the inclination of the powers that be in terms of enrollment, the role planner, the Chief Justice, the Judge President and the DJP, whether they see agency in the way we do, that we try and achieve an en bloc enrollment, deal with this matter and get it off our tables.
Indeed, my lord, I think that will be the best solution in the circumstances. My only worry, my lord, is Sergeant Musia. If maybe we could try and see if his evidence cannot be disposed of, before we, think of postponing the matter to another date, because chances are that we might even have to go into next year, and I think it will be unfair for this witness to have to come back after such a long lapse of time to finalize his evidence. So perhaps a shorter postponement just to dispose of his evidence, and we can then look at postponing the matter to a date when possibly all the evidence can be heard during that sitting.
Okay. Yes.
Thank you, my lord.
Before you continue, I'm remembering, sorry to interject, I'm remembering that yesterday I had a brief discussion with a member of my own family who has some insight into issues of court and decorum.
Yes, madam.
And that person raised the issue of my cap in court. And it is, when that happened, I realized that something very disadvantaging to the decorum of the court might be happening, which I did not intend. Because in here, there is only HO2, and it is not cold, it is hot, and I must take it just to clear that kind of air. It is HO2 and nothing else.
As the court pleases.
I'm saying it because before you rose, I had a sip. Yeah. Okay, let us proceed.
Thank
You can.
My lord, in response,
Yeah.
my lord, it is surprising to hear the state telling me that I need to be given a short adjournment when the state has put on record that it came to the attention of the state on the 23rd of March, my lord, before we started this case about the existence of this docket. And yet the state failed to disclose such information to me, my lord, before starting this case. I understand that the condition of the witness is not good, my lord. However, here, the violation of the constitutional right of the accused number 5 is imperative, my lord. And my lord, with due respect, I cannot be told by any of the counsels before this court as to how long do I need to do a preparation regarding the documents that I've just received now. And also myself, it will be unfair for me to tell them as to how long do they need to read that document. It's a further prejudice, my lord. It's a further disregard of accused number 5 constitutional right by the state. And a misjoinder of the accused in this case. We are sitting with a critical situation here, my lord, wherein I'm seeking clarity from both DPPs regarding Exhibit D, wherein they decided to charge other people and later stage decided to charge these people. I cannot be able to proceed without receiving a confirmation by way of a letter, my lord. I don't need witnesses here in this court. I need a letter, my lord, from the DPP confirming the status quo of the document that is before this court. Then I'll be able to move forward. And also in respect of the line of cross-examination that I need to do, my lord, to this witness, I cannot be told by the state, I cannot be told by anyone, my lord, with due respect, whether I should cross-examine or whether I should not cross-examine. That's accused number 5 constitutional right to decide how to conduct his case, my lord. The person who has put us in this trouble, the person who has put this court, this trial into shame is the state, who failed to disclose such a crucial information and decided to charge the accused who are before this court after they have charged other people. And I'm seeking clarity on that, and I'm being told that there is no need to seek for a longer postponement because I can be able to continue with this witness. My lord, that is very unfair, and it's very wrong coming from the state. The NPA, my lord, is not supposed, and he has got no right to charge people the way they want. As much as they are given, they've got rights in terms of the Constitution to decide, to make decision on the people to charge. But also there is a way, there's an administrative way of conducting such decision. In terms of Section 33, my lord, of the Constitution, just administrative reasons. Accused number 5 has to be informed of the reasons about the decision taken in Exhibit D because he is affected. He's an affected person, my lord. And until we receive those reasons, we will then be able to inform this court whether we're able to proceed or not. Just administrative reasons. Section 33 of the Constitution. The state must give us reasons, must provide reasons for the decision that has been taken. Whether there has been a misjoinder, or maybe we're supposed to be having 10 accused here. The other accused should have been joined here, or they should not have been joined. We don't know, my lord. As a result of that, my lord, I am asking that this matter be adjourned, and the remaining period of this session, which is until next week Friday, will be insufficient, my lord, for me to prepare this case. And therefore, I need a postponement further than to next week Friday, my lord, so that I'll be able to read, consult, and then prepare further for this case. My Lord, once more before I sit down, the gross irregularity that has been made by the state in this case, we have been made to plead before this court when we were not in possession of such crucial information, wherein there are other people who have been charged in this case. And we have already pleaded, my Lord. Then we need to go back and reconstruct all that information. And then the state is not even ashamed to stand up and say, we do not deserve a longer postponement. My Lord, I don't know. I need protection, my Lord, from this honorable court, my Lord, that I'm asking a reasonable time. A reasonable time, my Lord, will not be the remaining period, which is from today until next week. Then, depending on the availability and depending on the role coordinator who is coordinating the role, my Lord, we can then be guided of a further available dates for this court to resume again, my Lord. Those are my submissions.
I see that in your answer you compacted two issues.
Yes, my Lord.
There are issues of you on behalf of your client preparing yourself or acquiring readiness for purposes of the way forward. But there's a suggestion I made to say that we need to come together.
Yes, my Lord.
All of us engage those who are responsible for drawing court rolls.
Yes, my Lord.
Who will be the role planner, and then the JP or the DJP in this division, in terms of aspiring to enroll this matter en bloc.
Yes, my Lord.
I'm raising this because in other matters that with similar or even different length, I have seen that matters can be enrolled en bloc so that
Yes.
you deal with the matter. And I'm saying the justification, the specific justification in this matter
Yes, my Lord.
is that it took forever from the day of the incident to the day it saw its day in court. So you did not address that.
Oh, my apologies, my Lord. Thank you for
And
reminding me.
whilst you are about to address, it has been suggested that the remainder of the days in this week can be looked at in terms of putting together a meeting that can achieve that objective.
Yes, yes. In that regard, my Lord, maybe I would suggest that we adjourn until Monday. Maybe it can give us time to meet with the other role coordinators and all other stakeholders in order to look for a next remand. That's my suggestion, my Lord.
Okay.
Yes.
All right.
Thank you, my Lord.
Yeah.
My Lord, I do agree that we roll it over to Monday, and we can have a way forward on Monday. Thank you.
No, that was the initial suggestion. I don't know what elicited the tirade from my learned friend on behalf of accused number 5, but we understand. We've made it clear we're not opposing the request for a postponement. All that we did is just to put the various dynamics that should inform any decision. I mean, if she needs whatever time that she needs, we're not going to oppose it, my Lord. All that we did was to just inform the court of, the other factors that need to be taken into. I don't know if there was a misunderstanding, but the uncouth language like ashamed and so on, I think that was not necessary, my Lord. But we understand. As I say, we're just putting all the relevant factors before the court, and as already indicated, that perhaps we can then adjourn for a short period, just for us to find each other and to find a way forward.
That having been said, all I can say is that as for me, whatever I do or do not do, I keep in mind that there are people in custody. I keep in mind that there's a family that has buried a son, and there's a country, if not the globe, that has lost a remarkable individual, and that matter has been brought into our hands. It is up to the four of us to see to it that justice is done in any manner whatsoever, be it in the trial, be it in the postponements and whatever. So in line with the agreement now, this matter is postponed up until next Monday, so that we can be able to determine the way forward. I must just indicate that as the presiding officer, I did attempt to interrupt. I do not agree that with the situation as it is, Advocate Mshololo should be told when to be ready. I'm not saying anybody did, but I think we are saying she should be allowed reasonable time, and she has told us that that reasonable time shall be determined by the dynamics that shall confront her as she prepares from now. She also raised a matter that I didn't hear addressed, that from her side, on behalf of her client, they are going to seek reasons for decisions taken, for a decision taken. I think on Monday, I don't want to put anybody on the spot. On Monday, maybe we shall be able to learn what the response is around the intent on the part of Advocate Mshololo to seek reasons for decisions taken that have to do with this case. So on that base, shall the accused rise? This case is postponed with the accused in custody until next Monday. Next Monday, the date will be the... Yeah. This matter is postponed with the accused in custody until the next Monday, the 13th of June, 2022, in order to give space and time to Advocate Mshololo to deal with the discovery in terms of a docket 375 that has been made available this morning, to her this morning.
Kwenzeka ke bafethu besenizile ngaphambilini ukuthi ke ummeli wakhe ummangalela wehlanu ucela ke ukuthi inkantolo imiphi isikhathi ukuthi alungiseleleke futhi ahlale phansi afundele dokodo alitholileke kanye futhi ahlangane naye ummangalela wehlanu bakhulumisana. Kodwa ke okuzokwenzeka ke manje ukuthi ke umehluleli nabameli ke bazohamba ke bayohlangana ke nabanye ke ijaji lengamele nomehluleli wengamele kanye nabanye ke ukuthi ke babonisane ukuthi inqubela phambili yalecala kuzohanjwa kanjani. Sizobuya ke ngomsombuluko, kuzobe i-date kuyi-13 kuyona lenyanga esikuyona ke. Asibuyele ukuthi icala liqhubeke liqulwe, kodwa sizobuya ke ngenhloso yokuthi sizozwa ukuthi eliphi elinye ilanga elilandelayo esobuyela ngale nkantolo. Ngiyathemba ukuthi sezwana. It's understood, my lord.
Just maybe by way of clarity, should the witness be here on Monday?
From what I heard, the chances are very slim. Advocate Mshololo speaks of going through what was discovered and further consulting. I don't know whether it will not be ambitious of us to require him to be here. I'm noting that every step on his part seems to be an invitation to pain. And I think we should not be lacking in terms of that sensitivity. If he will be required, I think we'll be able to determine on Monday if that will be possible for him still to be back still on Monday. We'll have to forgo Monday and resume soonest.
Indeed, Malo, can we then ask that he be excused for Monday? If
Yes.
there's a need, we'll get in touch with
And that the state shall communicate with him
Yes.
in terms of when to be back.
Okay, Ntate Mosima, motjhutjhisi o tla buisana le wena ho fetisa date e latelang ka Mantaha o hloka le hore o be teng. Understood, my lord.
Anything else?
There is